What an absolutely joyful welcome. Fabulous. So we can't see any of you because we have the torture lights on us. So if we do this, forgive us. Welcome. My name is Jo Phoenix, and I am the... I am your chair for today. And we have an assembled guest here, or assembled guests. And although they don't need an introduction, I'm going to introduce them anyway. To my immediate left is Akua Reindorf, KC. She is here in her capacity as a barrister, although she is also a judge and a commissioner on the EHRC. I did get that the right way around,
You did.
Thank goodness for that. And next to Akua is Maya Forstater. You'll all know she is the founder and CEO of Sex Matters. And next to her is Helen Joyce. And I would like to introduce her as the Carmarthenshire News described her today as a controversial author of a controversial book. Where? So we've got around 2 hours, just short of 2 hours. There'll be about an hour and a half of us chatting. I have various questions to ask of the panelists, and then that should leave us around a half an hour for questions from the audience. So sit back, enjoy. Hopefully you'll get something from this evening. We will get a suntan in these lights, I think. Before I start tonight, though, I just want to make a bit of a comment. I want to say thank you very much to Outspoken Women for organizing this. It's quite a feat to organize because, as far as I am aware, there are some protesters outside. Outspoken Women have worked with the Taliesin Arts Centre, who have been phenomenal, and we have a whole host of security people. In fact, I believe we've had the security protocols that are normally or that were initiated here in Swansea for Hillary Clinton. Which in and of itself is quite a thing, really, if you think about it. We're just 4 women, but, you know, perhaps dangerous in our thoughts. Now, there is a context that I want to just note first, and that's that some of you may be aware that back in May, 2 senior executives at the University of Swansea published a statement on the internal web pages, the staff pages, in which they said that this event and 2 previous events had caused distress, and that that distress was likely to be ongoing. And so the University of Swansea have put in place special measures for the LGBTQI+ staff, students, and wider community. Again, some of you may know I published an open letter in response to that statement, in which I pointed out that that statement itself was likely to be harassing and that it was likely to incite problems on the university, or on the campus. I did receive a letter back from Professor Paul Boyle, who is the Vice Chancellor. In his letter, he said that that was an internal message, which I think meant I wasn't meant to have it, I don't know. But he said it was an internal letter, and that surely I could understand that the university had to respond to the concerns of their students. To that letter, I wrote another one. It's on Substack if you want to read it. But the point that I want to make is that we have invited Professor Paul Boyle to this event, and I don't see him present. No, I don't see him present. It's a pity that he wasn't able to come. Other university leaders, such as my own, Robert van den Oort from Reading University, comes to these controversial events. and will often speak to both the protesters and the people in the audience. So I just want to make a note of that. But that's not to say that I am not extremely thankful, as all of us are, for the superlative organization of the security staff and the Taliesin Centre. So, without further ado, I'm not going to speak so much. I'm going to open this evening with the prompt question that was in the description, and we'll just get each of the panelists to give us a response to it. And that's this: if any man can be a woman, or any woman can be a man, what use is the Equality Act in preventing sex discrimination? And we'll start with the lawyer.
All right. Okay, well, I will run you through then a probably fairly dry account of how it actually works, so that Helen and Maya can then tell you what they think of how it works. Oh, a baby, there's always a baby. Oh, lovely. Right, so the Equality Act, of course, doesn't allow any man to be a woman or any woman to be a man. It allows people who have gender recognition certificates to be treated, for the purposes of the Equality Act, as though they're of the opposite biological sex.
Possibly.
Under the current interpretation of the law, which is, of course, the 4 Women Scotland case, which I'm sure all of you will know about, excuse me, which the Supreme Court will be hearing at some point in the near future, is going to settle that question, or may settle that question. But at the moment, the law is that if you have a gender recognition certificate and you're a male-born person, that you're treated under the Equality Act as a woman. So bearing that in mind, and thinking also about how easy or difficult it might be to get a gender recognition certificate under current rules or any potential future rules that there might be, the way that discrimination works in the Equality Act, there are 2 types of discrimination, direct and indirect. There are also other things, but those are the 2 main forms of sex discrimination. And both of them are set up on a sort of binary system. So discrimination relies on a comparison of a woman's position with the position of a man. That's direct discrimination. Indirect discrimination is about whether or not a particular sort of provision or criterion or practice makes life harder for women generally than it does for men generally. So it's binary, and it relates to whether men are treated more favourably than women or women are treated more favourably than men. So if you then inject into that a lack of clarity around the edges of what is a woman or what is a man for the purposes of the Act, you get into all sorts of bother. And there is very, very considerable bother about the way that it currently works. So that what you do if you're bringing a direct discrimination claim is you say, I, as a woman, was not given a promotion, whereas, my colleague who's in the same job and is a man was given the promotion, and there's no good reason why he should have been. That man is your comparator. Now, if your comparator turns out to be actually legally a woman, because he's got a gender recognition certificate, or she's got a gender recognition certificate, whatever you want to say, that person can't be a comparator, and then you don't have a direct sex discrimination claim. If you're a trans person, this is where it gets even more complicated, and you've got a gender recognition certificate, you can bring a sex discrimination claim where if you're a trans woman, so biologically male, with a gender recognition certificate, you can compare how you were treated with how a man was treated. But if you haven't got a gender recognition certificate, you have to compare how you were treated with how a man was treated. I always get confused here with how a man was treated.
No, for sex discrimination.
Yeah, for sex discrimination.
Yeah.
See,
yes.
even the lawyers get...
You see, yeah, I have to have it written down in front of me. So if you're a trans woman, so you're biologically male, you haven't got a gender recognition certificate, for the purposes of the Equality Act, you're a man. And you can only bring a sex discrimination claim by comparing yourself with how a woman was treated. So it gets really, really complicated really, really quickly. And it's, you know, not just the lawyers who get confused about it, the judges get confused about it, the general public haven't got a hope in relation to it. But it really does hinge to an enormous extent on whether or not you've got a gender recognition certificate. So we hear a lot of things about how much difference it makes. Really, having a GRC, it makes a lot of difference, which is why the Supreme Court are dealing with it now. And this is before you even get into the question of other types of discrimination, like gender reassignment discrimination, where again, the complexities just become legion, and I won't bore you with what they are, but they are, you know, it's completely Byzantine the way that it works. And then further to that, the effect on how the exceptions in the Equality Act work, which are about situations in which discrimination is lawful. So when sex discrimination by a service provider can be acceptable under the Act if you want to have a single-sex service. When the difference that a GRC makes there is, again, really quite significant. And beyond that, the difference that it makes in relation to associations and whether or not an association can be restricted to, for instance, lesbians only. So, you know, the impact of the Gender Recognition Act on the Equality Act is very far-reaching and very, very confusing. And in my personal view, and this is very much my personal view, it's unsustainable, and it means that sex discrimination becomes very unstable. And it has a very significant impact on sexual orientation discrimination as well, even more significant. And in fact, arguably means that the categories of lesbian and gay man aren't even sensible categories that make any sense, because under the Equality Act now, a lesbian is a biological woman or a trans woman with a GRC who is attracted to biological women and trans women with GRCs. But not trans women without GRCs.
and not trans men.
And trans men without GRCs, but not trans men with GRCs. So it's nonsense. And it just, you know, it means that potentially there isn't a sensible category for anybody except really bisexual people under the sexual orientation discrimination provisions, which is really problematic. And unfortunately, the courts, the last time they dealt with it, didn't grasp that point at all. But yeah, so it goes further than sex discrimination. It means that every part of discrimination law where sex is relevant is affected by this and makes it very, very difficult. And to my mind, even though the Supreme Court are going to be dealing with it this year, it really is a matter for government.
Yeah. Thank you. Maya.
So I agree with Akua on some things and disagree on other things. We think it's simpler than this. We don't think a GRC changes your sex for the purposes of the Equality Act. The Equality Act, and we've applied to intervene in the For Women Scotland case in support of For Women Scotland, and it may be decided by the Supreme Court, or as Akua said, it should be decided by government. We agree on that. The Equality Act brought together dozens and dozens of pieces of discrimination law that had been put in place years and years before. The big one for this question was the Sex Discrimination Act, 1975, when I was 2 years old, which said you can't discriminate between men and women. There was no question in that act of what man and what woman meant. And there's no question that women are discriminated against because of our sex, because of our bodies, because of the fact that we have children, and because of the fact that we are the targets for male sexual attention. And it cannot be the case that all of that was thrown away when this was basically tidied up into the Equality Act. But in the intervening years, the Gender Recognition Act had been passed. And the Gender Recognition Act says, if you get a gender recognition certificate, it changes your sex for all purposes. And for a while, people got quite carried away with that, and they thought all purposes meant all purposes. Of course, no government piece of paper can change your sex for the purposes of me being able to see, even with these lights on, who's male and who's female in this room. Everyone can see that. It cannot change your sex for all purposes. The only purposes it can change your sex for are legal purposes. So it can change your sex for the purposes of other laws that relate to sex, male, female, man and woman. And we know that it changes your sex in relation to marriage, because that was one of the reasons they did it. We know that it changes your sex in relation to pensions, because that was one of the things in the court case that made them bring it. We know that it doesn't change your sex in relation to succession, peerages, sex crime, and parenthood, all places where sex matters. And then all of the rest of the laws, by default, you think, well, it applies to them. But they kind of tidied them all up. And if you look at the purposes of those laws, I think you have to say, well, what was the purpose of this law? Does it really make sense to say it changes your sex for the purposes of this law? So if you look at the Human Fertilisation and Embryology Act, which is very, very detailed about sperm and eggs and where they come from, where they go to, and the woman and the man, it doesn't say anywhere in it that the Gender Recognition Act doesn't apply to that. But if you read that, as Akua just did with the definition of lesbian or of sexual orientation, it does not make sense to apply the piece of paper to what's going on in the Human Embryology and Fertilisation Act. And so I think any court would look at that and say, of course it doesn't apply. Be sensible. If you look at what the Equality Act is really about, it's not directly about sperm and eggs, but it's about men and women interacting in the workplace in relation to services, being discriminated against because of our sex. So I think it's much simpler, and it should be much simpler, just to say we have the protected characteristic of sex. That means male and female. That protects everyone from sex discrimination, including trans people in their sex. So a trans man who, as we know, can get pregnant, a trans man who, everyone else may see as a young, attractive female and may get sexually harassed in the workplace, just like any young, attractive female who just happens to call herself he, needs to be protected from sex discrimination in her sex. And there's a separate characteristic that protects trans people from discrimination because they're trans. So that's how we think the law should be interpreted. That's how we hope the Supreme Court will interpret it. But it really is a question for government. I mean, it can't, it's been interpreted twice in Scottish courts the other way round, and it really does need to be clarified. And we think it does need to be clarified by government, because the For Women Scotland case is about the question, ultimately it's about the question of how do you count women on public boards in Scotland for the purposes of this equality thing. It's very hard to then get the judge who's looking at that to think about, well, what does this mean for showers, toilets, dormitories, women's refuges, funding for women's refuges, all of the applications of the Equality Act, because those judges are only supposed to be looking at what does it mean for women on public boards in Scotland. Whereas if it goes back to Parliament, then they have to think about these things and think about what is it we're really trying to do. Are we trying to give these men a piece of paper that says that you can go into a women's toilet, a women's shower, that if a woman calls for a female doctor, that you can present yourself as a female doctor? If a woman is being searched in prison or by the police, that a police officer with a piece of paper can search her? Is that what we're trying to do? Or was that a mistake? And either way, it needs to be tidied up. It needs to be clarified. It needs to be clear so that everyone can understand it. And they need to be able to understand it on the sides of a postcard. You can't bring Akua with you to make these arguments when you go to the toilet.
I'll probably forget who you're comparing to.
And these things have to be implemented by, the 18-year-old gym assistant on reception. They have to be implemented by teachers in primary schools and people running pubs in the middle of nowhere who have never read the Equality Act and just want to do their job and keep people safe. And so it needs to be really simple and clear. And we think it does have to go back to the government in the end.
I think what we've heard is that when you break a fundamental definition, a lot of things become more complex. But I want to argue something that's a bit stronger than that, which is that when you break something fundamental in a definition, you don't just have problems around the edges. You don't end up thinking like, who's my comparator? What you do is you turn the law back to front, completely back to front, so that it doesn't just do something that wasn't what you intended, it does the opposite of what you intended. And I didn't understand that when I started out on this, but I see it all the time now. And just today I was reading a thread that I think Joan Smith was writing about, and she was talking about the possibility that there might be a law that would ban misogyny, like treat misogyny as a hate crime. But the thing is that anywhere that's considering doing this also says that trans women are women, and says that transphobia is also a hate crime. Well, what's transphobia? So transphobia is saying that a man who says he's a woman is a man. And that might be in a context where you have to protect women's rights. So it might be in sports. It might be that a woman who is trying to compete in a fair competition is saying this is not fair because this person is a man. And she can try and use whatever language she can try and say it as nicely as possible. She can not do what massive bigot Helen Joyce has just done and call him a man. She can say trans woman, this trans woman, she shouldn't, she has a biological advantage. That's transphobia. And so then it's not just transphobia, but it's misogyny because this person is a woman. And so what the misogyny hate crime will become is really, I think exclusively, but at least mainly, a tool to use against women who are trying to protect women's rights against men. It will be used to tell women that they aren't allowed to say that a man is a man, that they're not allowed to ask a man to leave a space, that they're not allowed to refuse treatment from a doctor who's a man, that they're not allowed to refuse being searched by somebody who's a man, as a police officer. It'll be used to argue that you're not even allowed to explain why you need male people not to be in women's sports, etc., etc. So what it will be is it will be the misogyny law. It'll not be the anti-misogyny law, it'll be the misogyny law. So when you break these rules, that's what happens. Everything that was made to protect us turns to be used against us. And I want people to keep that in their minds and not get too lost with the question of, who's the comparator or whatever, although that's how, of course, it plays out in the court cases. What happens when we break this is that the thing that was meant to work for us is now a tool that is going to be used against us.
Thank you. Thank you. So, it's often said that what we are trying to do is take trans rights away. And I want to kind of have that as the question, or not the question, but that in the background of your head. Is there a right to self-identify? Is that a protected right?
In our law?
Yeah.
No.
Okay.
No, it isn't.
Yeah.
And that's a really important point because there is a myth that is prevalent on social media that the Equality Act gives...
Equalities Act, I think you'll find.
I have ordered the T-shirt that has been produced by Billabalower that says it's the Equality Act 2010 in bold. I can't wait. When I get home, it'll be waiting for me. The Equality Act is thought by some people to give a right essentially to self-ID because it's being misread and misrepresented. What the Equality Act does under the protected characteristic of gender reassignment is that it protects people with that protected characteristic, which we can broadly call trans people, although it won't cover all people who identify as trans, from being treated badly because they're trans by comparison to people of the same legal sex as them who aren't trans. So being bullied or being sacked because they're trans or whatever. What it doesn't do is protect people who are trans from being treated as if they are the biological sex that they are. So it doesn't mean the right not to be bullied because you're trans, for instance, doesn't imply a right to be treated as though you are of the acquired gender that you claim to be. It just doesn't work like that. And one of the technical boring, again, I'm going into the dry black letter law here, but if you're a trans person without a GRC, so you're a trans woman without a GRC, under the Equality Act, you're a man. And if you're bringing a complaint of gender reassignment discrimination under the Equality Act, you have to compare, again, it's the comparison, which is at the heart of the Equality Act, the comparison exercise, to compare the way you were treated with the way in which a man was or would have been treated in the same circumstances. So you say, okay, I was, somebody put a horrible note on front of my locker at work, and they didn't do that to my colleague who was not subjected to that treatment. That colleague needs to be a man because he's a person who is the same as you and in the same circumstances as you are, apart from your protected characteristic, which is what the comparison has to be with. Somebody who is, to all intents and purposes, the same, apart from they don't have your protected characteristic. So that includes having the same legal sex as you. Whereas if you're a trans woman with a GRC, then you can compare the way you were treated to a woman. So it's a bit more complicated in that context. So it just simply doesn't involve the right to be treated as though you're of your acquired gender at all. I mean, there may be circumstances under the indirect discrimination provisions where you might be able to bring a claim that as a trans person, or trans people generally, and you as an individual trans people are put at a disadvantage by not being treated as if you were of the acquired gender. But it's a real long shot in many factual scenarios, in all factual scenarios, I would say, and is by no means a slam dunk at all. Indirect discrimination is very, very difficult to prove, and there are lots of steps that would be difficult in a claim of that sort. So no, certainly the Equality Act does not give any right to self-ID. That is definitively the case. The GRA, the Gender Recognition Act, doesn't give any such right, obviously, either. There is one and only one legal route to being treated for most legal purposes, or no, not even most, many legal purposes, as though you're of the opposite biological sex, and that route is to get a gender recognition certificate. There is no other route. If there were, there'd be no need for GRCs.
Moving on to go ahead.
Can I answer that question?
Yeah.
Sex Matters is a human rights organisation. We want to protect everyone's human rights, and underlying the Equality Act are the human rights. And so when people say trans rights, we want to know what rights are they? What human rights are they? Because human rights are universal. Everyone has them, they're the same. And the European Convention on Human Rights, which is the one that applies to us, says wear what you like, call yourself what you choose, have sex with anyone. Oh no, it doesn't say that. No. But it does, basically. And so it says you have freedom of belief, which is close to my heart, freedom of expression, Article 10, freedom of expression. And in that respect, you do have the right to self-ID. You have the right to say, I'm a woman, I'm a man, I'm non-binary, I'm a trans femme. You have a right to wear what you like, not when you're at work. When you're at work, you've got to wear what's in your uniform or your workplace code. So the right to self-identification, as in to call yourself what you like, you do have that right. That's your right to freedom of expression. But it's not an absolute right. It can be constrained. And you have the right to lie about, you have the right to lie in your private life. The government can't come around telling you have to tell the truth, apart from in situations where you do have to tell, the truth, the whole truth, and nothing but the truth. And, that's when you're dealing with the law and the state and officialdom, and where the state is coming between you and other people and saying, actually, here, you do have to tell the truth because we're imposing a rule and the rule is fair, and in order for us to impose this rule, we need you to tell the truth. And in some situations, if you don't want to tell the truth, fine, go somewhere else. Don't engage with this particular rule. Don't engage with this particular service, which is for women only. But live how you choose in other spaces. And I think, then because there are people who feel uncomfortable, unhappy, in those situations, services do have to think, particularly where you divide people into male and female, in order to get from one place to another. So in order to get on a plane, you have to be searched. But it's a very small part of getting on the plane. You don't want to say that some people can't get on a plane, or they can't go to a concert, or they can't go to the cinema. So you can try and make those, you can make accommodations for people as you make accommodations for people with all kinds of special needs, but you don't have to break every rule, and you don't have to say people can lie in places where you expect people to tell the truth.
Can I just kind of push it a little bit further? There's a really important question, I think, that a lot of activists are asking themselves, and that's why don't we just get rid of the GRC and the GRA? Just repeal all of that.
Yeah,
wouldn't that help?
Shall I take that?
Go for it.
So about 9,000 gender recognition certificates have ever been given out, as far as we know, and there's probably about 6,000 people who have them. You may notice it's not 6,000 people who are claiming that they have the right to use spaces for the opposite sex, and that it is not the fact that, despite what Akua said about how there is no right to self-ID, what's happened is that, in fact, self-ID is the de facto law of the land. Some people call it Stonewall law. So if we got rid of the Gender Recognition Act tomorrow, I don't think anything would change. The Gender Recognition Act was an extremely important part of what got us here, but flicking that switch wouldn't get us back, because it was a stepping stone, and the law and the practice has now gone way, way, way beyond the law in most places. So in one way, it's way under-ambitious. Like, getting rid of the Gender Recognition Act would do almost nothing. But in another way, it's over-ambitious, which is that if you look at how it came to be, it's in response to a case that went all the way to the European Court of Human Rights. So that was the case of Christine Goodwin, who was a bloke in his 50s, who was a bus driver, who went and he wanted to do paperworky type things like, getting a loan or something like that. But he had to, this is an analog times, this is the early 2000s, you had to show your birth cert as part of your ID. And in his mind, this outed him as a man. We've seen video of Christine Goodwin. It did not out him as a man. But listen, people have the right to their own thoughts about themselves. We all of us have some fond delusions about ourselves, I'm sure. He didn't want to have to show that he was male. And then this, in the fullness of time, made it the whole way to the European Court of Human Rights, where, by the way, the plaintiff doesn't appear. Like, plaintiffs appear in the first case, and then after that it's paperwork. So the people weren't actually looking at Christine and thinking, I don't really feel that your privacy is majorly at risk here. And they decided that there was a privacy right that for these people who had gone through, and they went into this very purple prose about how much they had suffered and what they had gone through and extreme cases, and society needs to make accommodations for them, etc., etc. These people had to be given a way to get a birth cert that falsified their sex. And then, of course, the UK government went and gold-plated it and said you didn't have to have surgery and so on. Undoing a law that was in response to a European Court of Human Rights judgment, if you have a way to do it, please feel free, because we don't know how to do that, and it would take 20 years, and it would be everything, all our time and effort, and it might not still work. And anyway, like I said, those 9,000 pieces of paper are not the problem. So we feel that at the same time, it's too ambitious and not ambitious enough. And the thing is that if you fix the Equality Act, then you start the process whereby you start to say, as Maya said, what is this? What are we trying to do here? Why are we telling men that they can't come into this space? Well, because girls are getting naked in this space, so we can't have men in there. It's a shower. Piece of paper is irrelevant to that. Every man in the country could be given a GRC saying that he's a woman, and we still wouldn't want them in here. So that's why we are focusing our efforts where they are. Very happy for people to say repeal the GRA. I've got no brief for the GRA. It's just why we're not, that's not where we're putting the effort of our less than 10 people in our small but perfectly formed team.
And we think by putting the focus on the Equality Act, it's putting the focus on women's rights, it's putting on the focus on the everyday law that people are applying all the time, because the world is full of men and women. Rather than, if you focus on repealing the GRA, it's all about taking away trans people's rights. So what we're asking, effectively what we're asking is for Section 9.1 of the GRA, which is the bit that says for all legal purposes, to be repealed in relation to the Equality Act. And the Equality Act is the great big law that affects all our lives in so many ways. So that feels, and that allows us to have a conversation with politicians and with the public that's about single-sex services, women's refuges, showers, toilets, searching, the practical implications, rather than if you start having a conversation about the GRA, the first thing is people go, what? And you have to explain the whole thing to them, rather than say, do you think, you know, as Helen Stanaland says, women and girls should be able to have a shower in peace without male people coming in.
And we can keep saying it's about our rights. Like, you know, the very annoying thing that's happened during this election campaign where, you know, somebody phones in and says to one of the politicians, you know, why do you not care about women's rights? And they start talking about trans. Why are we talking about trans? We need to be talking about women and men, and in particular women.
Yeah. Brilliant. So just one last question on matters of law. We've had, just as we were sat in the wings, I was thinking that 3 years ago I was not even embroiled in a legal battle yet.
You were short. Yours was a really short one. She was 4 years.
Yeah, yeah. I was short, relatively. I am short.
Compared to Ben Cooper, you're talking about now.
Well, but anybody, you know, compared to everybody. I identify as very, very tall. We've had a lot of legal wins since even just 3 years ago. What do these legal wins show? Do you want to start?
Well, I can say very shortly what I think they show, which is that judges do largely, by and large, understand the law and apply it properly and understand how to conduct the relevant balancing exercises and how to I mean, almost all of the cases have been in employment tribunals, so I'm going to bang the drum for the very fine jurisdiction of the employment tribunal, where we deal with very, very complex law, much more complex than most people think, and the Equality Act is particularly complex, especially when it butts up against the Human Rights Act, and those are the two pieces of legislation which come into play here and require a great deal of balancing. And we have seen in case after case that the judges have undertaken that process very effectively. There have been one or two situations where, where there's been a bit of a slip, but they've ended up with us getting appellate decisions which have been certainly very useful for my own practice, I must say. So that's to be applauded. I've seen quite a lot on Twitter from activists to the effect that these cases have been lost, essentially. Only, you know, one or two small points, technical wins, and so on, which I've been slightly flabbergasted by. But I think there's a lack of understanding that nobody, almost nobody, ever wins every single point that they fight. These have been, it's been a stunning line of case law. I've been a barrister for 24 years now, and I've not seen a line of case law like it in that time, and I feel extremely privileged to be working in this field, actually.
I just want to abuse my position as chair and say one or two judges are incredibly well written in their judgments, and all I'm going to say is paragraph 22.
So after my case and my appeal, where it was found that gender critical beliefs are worthy of respect in a democratic society. I think there have been 6 other cases since, and it's interesting, even in my appeal judgment and then the judgment in my case after, the judge were quite wary of saying anything nice about me, basically. You know, they decided, you know, not quite a Nazi, worthy of respect, you know, you can have these beliefs, but, you know, they're quite offensive. And then over the course of the 6 cases since then, you can see the judiciary kind of warming up, and you can see them looking at the complaints on the other side. I think in my case, it was the first time they'd seen this, and they really thought, well, these people who are complaining, you know, they've got good jobs, they're serious people, they seem very upset, you know,
they're in the, have done something.
Yeah, they're in the LGBT community or they're allies, I mean, and they'd been trained, you know, and they'd had the Equal Treatment Bench book, and, you know, these are good people, good, smart people. She must have done something wrong. We can't really find out what it is, but we're not going to say anything nice about her. And then over the course of the judgments, you can see it sort of dawning on them that something is wrong in these institutions. And I don't, is paragraph 22 the one that says, I had all these academics in front of me.
They lacked a certain robust...
Yes, yes. You know, and you can see this dawning on them in the case of Rachel Mead, the social worker, in the case of Denise Farmy, who worked for the Arts Council, you know, whose colleagues created this petition against her. Rachel Mead, it was one colleague witch hunting her that started it all. And in Ros Adams' case, I mean, by that point, you can kind of see the judges going, what is going on in these organisations? So I think that's quite interesting. And they all obviously read each judgment. So I hope it gets easier to show when people get to tribunal, or hopefully, you know, before they, so that they don't get to tribunal, that these complaints are unreasonable. And I think one really important thing from the Denise Farmy case was it was the fact of having the complaints and having the complaints, unreasonable complaints being investigated was harassment. And in the Rachel Mead case, calling her beliefs transphobic and bigoted was harassment. You know, if you take any group of people with a protected characteristic, you know, if you say, you know, the Irish are lazy, sorry, just, you know, a random example.
I'm putting the case in tomorrow.
Oh, yeah. But, you know, any example of a group of people, and you say, these people are a bad thing, that's harassment. And all over workplaces, they're saying, you know, zero tolerance of transphobia, asterisk, transphobia is basically defined as us. That's harassment. So, so there are going to be lots more cases, but hopefully they're going to get easier, hopefully they're going to get cheaper, and hopefully employers are going to get smarter so that they don't end up in that situation.
I don't think we can promise cheaper.
Well, quicker. Quicker, because the judge, you know, the judges...
to be able to have Akua being able to buy her T-shirt,
yeah,
right?
Exactly. I don't mean quicker by hour, I'm cheaper by hour, I just mean quicker.
Fewer hours. No, but I do agree it is preposterously expensive to pursue tribunal cases, and we have seen one or two, I think, where people have tried to do it on their own and have been less successful, and it is an area of law. I mean, I would never advise somebody to go to tribunal on their own, but particularly not in this, where the judges are less at home in it and where the law is complicated.
I mean, it's taken a long time to get to here. So when the Race Discrimination Act came in, there was, you know, basically there were a set of cases that came to the equivalent of employment tribunal. I think they were called industrial tribunal at the time. And, you know, the first ones, employers would turn up confidently and say, oh, it's not me that's the biggest, you know, it's my customers. I can't have a black person at the front of house. Like, no one's going to come in here if I, you know, and they're like, no, sorry, you've lost. Oh, well, they won't work with him, you know, that sort of thing. So it sort of, roughly speaking, took about a decade before employers actually got the memo that no, you can't say it's because the staff are bigots, it's because the customers are bigots. Just no, you have to treat people fairly. So that's kind of a discouraging, it's going to take a decade. But I'm sorry to say I think it'll take longer. Because if you think about the history of racism, it's not like there was some wonderful non-racist bit before we all suddenly decided, bizarrely, that we were going to pay attention to skin colour. Which is what has happened here. Like 30 years ago, we weren't doing this. I mean, we were discriminating against women big time, yes, but we weren't pretending that sex wasn't real and discriminating against people who said that sex was real. So we taught everybody to do that, and now they think they're doing the right thing, and we've got a whole load more workplace training than we had 30 years ago. I mean, nearly everybody has been through some workplace training, and the stuff that we see is appalling, absolutely ridiculous. Like, it gives examples of transphobia that are, you know, saying, sorry, this is the ladies, to a man, you know, that sort of thing. So everybody's been trained in all of this stuff, and we have to try and rip it out. And the thing that I found most surprising and disturbing after this run, this extraordinary run of wins, all wins on our side in a row, is how little difference it's made to practice. I mean, Riddle Wadwa is still running the Edinburgh Rape Crisis Centre. I know, and I mean, you know, Social Work England I don't know if they're going to do the things that they were told that they should do in their employment tribunal. I mean, Jo's old university, Open University, said that it's going to do a review, and it picked a legal advisor for that review who spends her time saying things about TERFs online. They've got rid of her now, but I mean, it feels like the levers are broken to get the institutional response that we need from these wins. So what can we do in that situation? I mean, I think the obvious one is just that it's actually very expensive. I mean, our estimate was that the OU spent £1 million.
Easily.
Yeah, against Jo. Like £1 million to defend a bunch of bullies trying to destroy a woman's life. You know, that's enough money, you know, that's the sort of money, sooner or later, £1 million here, £1 million there, it adds up, you know. So you can start saying that to people. If you want to be spending this sort of money again and again, you can if you like, or you can actually start to think about this properly. But it's not going to be as easy as I thought it would be a year or two ago. I thought employers would go, oh, we've got this wrong.
Yeah, well, I mean, I think the reason why they haven't changed as quickly, perhaps, as they might in the face of such an extraordinary line of case law is to do with something that one of you two raised a moment ago, which is the training and the external bodies that come into workplaces and other institutions to deliver training, which is just simply erroneous. I mean, it's so deeply rooted, and you know the outsourcing of that sort of training, which purports not to be legal advice, but is obviously taken as legal advice because it's about legal things and it's training about how to comply with the law. So one wonders how it can be not legal advice. It's just very deep rooted, and people don't know which way to turn.
It raises, for me, it raises a really big question, though, and it's one that, although I won, and I'm very happy about that, it's one that I still struggle with, both intellectually, politically, and just on a personal level, and that's how we turn judgments into justice. Because I think that's, you know, the driver for most people, and Maya, you can correct me if I'm wrong with you, but the driver for most of us who go to law is to attain some sort of justice, and yet judgments aren't quite translating as quickly as they'd like. So I'm going to leave you out of this, and just, sorry, I don't mean that dismissively.
No, it's fine. I was just going to say the judgment is supposed to be the justice.
Yeah.
That's how we think of it. But I mean, I understand you want something further than that.
Yeah, well, it's, you know, it struck me as the most amazing thing in an employment tribunal that the judgment, yes, it's the justice, but the employer can carry on doing exactly the same thing. They don't actually have to do, I mean, they might be facing legal cases, but they don't have to change. So just, yeah, judgments to justice.
I think it was you that told me when I was in my case, don't expect justice.
Yeah, it was.
Don't expect, you know, kind of anything, you know, emotionally what you need from it. And I thought that was good advice. But I think, you know, it was such a weird thing to be having to bring a case based on the belief that men are men and women are women. It just such a weird thing. And my case and most of the other cases that came after were all about people wanting to talk about this and being disciplined or harassed for wanting to talk about it in general terms. You know, Jo wanted to talk about prisons, but she wasn't a prison officer. I wanted to talk about, you know, toilets and changing rooms and all kinds of things. But actually in my office, it wasn't a huge office. We had one, you know, single toilet like you have at home. But the cases, the most recent ones, particularly Ros Adams and Edinburgh Rape Crisis Centre, was about somebody whose job, where sex mattered in her job, and in order for her to, you know, be able to keep her clients safe and treat them with respect, she had to be able to say that sex is real. And the judge in that case, they, like all of these judgments, they start with, I'm not saying anything about trans rights and women's rights, you know, but you are. And the judge in the Ros Adams case said that, you know, I'm not taking a position between the position that sex is real and immutable and the other position, which is mad. No, they didn't say that. And I'm not taking a position on that. But then if you read the judgment, really they did take a position on that because they recognised that what Ros was doing was sensible in her job. And now the cases that are coming now, the cases of the nurses in Darlington and the nurse in Fife, are about applying the same ideas how does this work when you're talking about an employer's changing rooms, an employer's toilets, employers who are employing people and safeguarding? And in those cases, I think they're not going to be able to carry on. They're going to have to resolve it one way or another so that they actually change their policies. It's not just about, of course you have the right to say these things on Twitter, which is good, or in the democratic process, which is good, but that employers are doing a job, and that job often involves being clear and reality-based about sex. And I think that is where we'll get to with more of those kinds of cases.
And I think, sorry, just to interject, but I think, hopefully the judges will have regard to the Supreme Court authority that they do actually have to grasp the nettle in these situations when it's necessary to do so. It's been, I think, a slightly disappointing aspect of the case law, the number of judges who've said, I'm not taking a position. And in fact, the full-page disclaimer at the front of Maya's Employment Appeal Tribunal judgment, which so many people are treating as if it's the judgment itself, which it isn't at all. But this sort of insistence that they're not taking a position is just really unhelpful, extra fluff. And there is authority to the effect that they really do need to come down on a side, pick a side in circumstances where it's necessary for the judgment to be effective.
I think that there isn't a symmetry here. I know that sometimes people say, why did this case have to be brought under belief discrimination? It's not a belief that there are two sexes, it's reality. And, one answer to that is you use the tools that are available. What do you want people to not be able to talk about this at work, or do you want them to be able to talk about it at work so we can fix it? But more than that, I would say that the belief, and if you read what Maya said her belief was, there's two parts to it, a bit like saying that you believe in man-made climate change is a very serious problem. Like, there's a bit that we never have to say with that, which is, there are solids, liquids and gases, and there are certain elements, and the methane is a greenhouse gas. We all take those as facts. And then on top of that, there's the belief that man-made climate change is a big issue. So you could say, well, there are two sexes, that's actually not a belief. And that matters. That's the belief bit. There are people who think it doesn't matter, or that we shouldn't be allowed to talk about it, or that women are just all whinging, and if we want to be able to work, then we have to accept having men get their cocks out in our showers or whatever. Like, there are people who have all sorts of mad beliefs on top of the facts. I won.
I was just going to say
had a bet. We each had a word that we had to say while we were on the stage.
That was not one of them. That was not it.
That wasn't it, though. That was not your word.
And cock was not the word.
It was penis, so I think I win.
I think I trumped that. Anyway.
Vagina.
Yeah, So what helps in all these situations is, on our side, is clarity. What helps them is obfuscation. And things can only, like, if you clarify things, you can't reconfuse them. Like, they've managed to do an awful lot of confusing, but if we managed, for example, to clarify the Equality Act so that sex really means sex, like, people say, well, Labour will come in, or some future government will, or what if, the EHRC loses its way again, or something like that. And well, what? We go back to saying, maybe it is sex or maybe it isn't. That's not the way laws work. If it's really clear, it's very hard to then confuse it again. So sooner or later, we get to the point, whether that's because of a legal change, guidance, Supreme Court judgment, a series of case laws, where we really know the answer to the question, this woman needs to have an internal vaginal exam. And she has said she is only willing to have it from a woman. This man has a piece of paper saying he's a woman. Does he have the right to walk in and stick his fingers in her vagina? We have to have an answer to that. And if the answer is, he has a GRC, you bigot, then we have to follow that chain of thought all the way to wherever we have to say women have human rights too. And this is Article 3 violation, by the way. And if, as I hope, they say, well, you know what, we didn't actually think of that when we wrote this law. Of course he doesn't. Then we're off to the races that way. So clarification is what we want, or clarity.
So that got through question 1 in my notebook.
And we also said all the words, I think.
Yeah, well,
I managed to get away without saying any of them. We're pleased with that.
Let's see if this one teases it out then. Is it legal to exclude trans women from lesbian space?
Well, that's a big one.
Sorry, that was...
Right, so on this, it's a real problem. I spoke earlier about, or I mentioned earlier, there's the exceptions which allow service providers to discriminate on the basis of sex, and so that they can have single-sex spaces. And that services are, you know, things like leisure centres and toilets and so on, things which are open to the public. The separate stuff in the Equality Act on associations, which is where you have basically a club or something like that, where it's got 25 or more members and has rules of admission or selection processes for allowing people to join. And in relation to those associations that fall within that description, there are no exceptions under the Equality Act. There's no legal way to discriminate in relation to those. So if you have, but what you can do is you can have an association which is limited to one or more protected characteristics. So you can have an association which is for women only, or for lesbians only, or for black people only, whatever it is. But you can't also, if you have a lesbian-only association, for instance, you can't exclude people with GRCs, trans women with GRCs from that service if it falls within, from that association, I'm sorry, if it falls within the definition of association. I mean, there may be some very tricky sort of legal argument that could get you out of it based on human rights or based on gender-critical protected beliefs or something of that sort. But the basic rule is, if you've got a club for lesbians, 25 people or more, with rules of admission, rules of membership, you know, a cycling club, a book club, whatever it is, you have to allow trans women with GRCs who I say they're lesbians to join it. So that's the law, even if they have a penis. So I've said it now.
So that's because of For Women Scotland that you're saying it's
Yes,
the law.
yeah, that's
Yes.
the law current as it stands. Yeah, I mean, the Supreme Court, in For Women Scotland, at the last stage, where it was heard in the inner house of the Court of Session, the judges didn't, I think, if I could say it charitably, grapple with this issue particularly profoundly, and they felt that it wasn't really an issue. I think it is an issue. I think it's a very big issue. And it's one of a number of issues which affect a protected characteristic of sexual orientation, particularly strongly in relation to the impact of the GRA on the Equality Act. It really does cause a problem. Of course, if you've got an association which is fewer than 25 members or doesn't have rules, which is a bit of a tricky one if you've got more than 25 members, then you can do whatever you like in relation to your membership. Probably something to bear in mind. But, you know, any sort of sizable association, there's a difficulty. And there are other provisions elsewhere in the Act, like the occupational requirement provisions, which can relate to employment. There are provisions relating to charities and so on. You know, in fact, there's a really helpful advice from Naomi Cunningham. It's a couple of years old, but I think it's been put out.
Yeah, it's in the bar.
It's in the bar.
But it predates the For Women Scotland judgment.
It predates the judgment, but it still, you know, sets out the basics on that. But yes, there is a reason why lesbians and gay men are particularly upset about the impact of the For Women Scotland judgment. And that comes on top of the basically complete decimation of the lesbian scene in general.
Hear, hear.
And I think one thing to add to that is an effect of the law. It's not just about an individual trying to join an association. It's about whether a venue or a public funder or a public body can discriminate lawfully against that association by saying, you know, we're not going to fund you because you don't allow trans women in, or we're not going to rent you this venue because you're not inclusive in this way. And, you know, they're usually not drawing the line at GRCs in any case, but, you know, that's also the problem is organisations being discriminated against because they're trying to express their freedom of association. And underlying the Equality Act are the human rights. And the reason why associations is different from services is because associations are expressing the human right of freedom of association, which is, you know, when you employ people, you have to employ everybody. You can't say, you know, we're only going to employ lesbians, for example. But if you're having
well, if there's an occupational
no,
requirement.
if it's an occupational
There are
requirement,
occupational
but
requirements,
not just because you just like employing lesbians.
No, although that would be great.
Yeah.
I like it.
But as an association, you can be whatever you want. That's what freedom of association means. And so if it's true that a GRC has this effect that Akua says it has, then it is breaching human rights. And we think it's breaching Article 11, freedom of association, and it's breaching Article 3, which is the freedom not to be subjected to torture and humiliating treatment. And that includes anything to do with being forced to undress in front of members of the opposite sex. And so if the Equality Act is breaching our human rights, we may end up having to fix this in the European Court of Human Rights, which is what the trans rights movement did.
So we have about 25 minutes left before we throw it open to the audience. And so I'm being selective in the questions that we thought about. Can we go to a Welsh-specific one? And the gender quota.
Yeah.
I think the audience might like to hear your views.
Right. I fear the audience are going to be much more knowledgeable about this than any of us. The gender quota bill, which isn't actually called that, but because I haven't got it written down, you haven't got it written down either. It seems to be a bit, have put the Welsh government in a bit of a pickle, but they don't seem to be perhaps noticing the pickle.
Nicely said.
I mean, as I understand it, and I'm sure people in the audience will correct me if I'm wrong, it is a bill which will require political parties, all part of the reform programme, and I'm not going to talk about closed lists because I don't understand what they are, but they will require lists of candidates to be at least 50% women, but uses the word gender, both in the bill, I think, and in the explanatory note, rather than sex, without giving any clarity about what that means, and also makes it, because at the moment the Equality Act allows political parties to employ discriminatory selection processes, but only in order to redress inequality or underrepresentation of women. But it doesn't mandate them to do it, it only allows them to do it. What this bill will do is to mandate political parties to redress underrepresentation, and in addition to that will do it by applying some definition of gender which is wholly unclear and seems to be really basically self-ID, because it's asking the candidates to make a declaration about whether they're a woman or a man, or not a woman, sorry, in which, and there's no penalty for lying. It's exempt from the penalties for lying in relation to other parts of the process. So it's really problematic in a number of respects, and the most recent thing that I saw was a report, very lengthy and detailed report from the Reform Bill Committee, stating that essentially, well, I can't remember what the detailed recommendations were, but they include that the thing should be put on hold while the question of whether or not the government is even competent to pass this legislation is dealt with. Which, because it effectively overrides the Equality Act, and that's not it just shades of Section 35 and the Scottish situation, the Scottish gender reassignment. What's it called, the bill?
Gender Recognition
Reform Scotland Bill. That's the one. Come back. I mean, it just seems like a full replay of that situation. It seems to me pretty clear from what I've read that the government doesn't have the power to change Section 104 of the Equality Act in the way that it's proposing to do. It's also really problematic in the sense that it seems to be bringing in a sort of form of self-ID in relation to this small area. But again, I think it was Maya who was saying earlier, or it may have been Helen, that there are all the litigation and challenges that we're dealing with are all about these sort of issues of this particular, quota or that list or whatever. Nobody's grasping the nettle of dealing with the thing overall. And this looks like it'll be yet another exercise in that. And I don't think that the Welsh Government is showing much sign of seeing the thing globally. I've looked at the LGBTQ plus action plan. Doesn't seem to indicate very much intention of taking a more moderate tone or more moderate approach to these matters more generally. I just don't understand what the government thinks is going to happen.
Can I say something about it, which is that when I started to think about the Scottish example, which is also a quota, but it's quotas on public boards. Originally, they wanted to have 50% quotas women on public boards, and women will be self-ID. For Women Scotland appealed, took a challenge against that and won. And then they changed it to women, meaning the definition as altered by a GRC. And I remember thinking at the time, well, oh, come on, there's hardly any GRCs. And I mean, 50% is kind of a notional figure anyway. What does it matter if it's 49, 51? And I've probably said this in meetings, because we go to a bunch of meetings and talk to people, and I said it over and over again. And then one day, I thought, think of Mriddle Wadwa. So what this bill does, what the Scottish version that has been stayed by the Section 35 order does, and what the gender quotas bill here would do, is not say we're trying to get 50-50 women, but you know what, it might be 49% real women and 51% real men. What it does is it gets some men to count as women. And one man who counts as a woman, who can sit there and say, I, as a woman, say we should have gender neutral toilets and we should have a parental leave policy instead of a maternity leave policy, etc., etc. That man can turn the organisation upside down in the way that a man who admits he's a man can't. So I now see it actually as really serious, like really serious, at least as serious as, can policemen search cross-sex people, because look what Mriddle Wadwa has done to the entire Scottish rape crisis, the whole of it, not just Edinburgh rape crisis, one man. So,
although that wasn't the act that was stopped by Section 35.
No, I know it wasn't. I just mean you only need one. It's not like there's one man running a rape crisis centre. There are men who run women's centres in around the country occasionally, sometimes for reasons because it used to be a women's centre and then it became one, and there are rules for he doesn't go into some bits of it or whatever. This is a man who says he's a woman. That's a completely different thing. So it'll be another example of this general law that what was brought in to help us will be used against us. That man will spend his time destroying women's rights.
Can we perhaps, with your forbearance, move on to the question of schools? I'm just really thinking mindfully. We've got 20 minutes, and I think if we move on to schools and then maybe think about next steps, next government. So, Maya, Helen, do you want to talk about schools? And the question, I'll just throw it wide open. What are the problems? What do we need to do? Where do we need to get to?
Explain why we took schools as a major focus at Sex Matters.
So when we started Sex Matters, we thought about sex matters in all of these different sectors of society, and schools was one of them. But it was just it was just one place. And after about a year, we stopped and we thought actually schools is much more important. It's not just one place where sex matters. It matters particularly in schools. One, because you're protecting children, and children are uniquely vulnerable. Two, because children being convinced that they're born in the wrong body, those specific children are being harmed, as the Cass review has shown. But three, the other children are being brought up into this ideology of believing that sex doesn't matter. And those children are then going on to jobs or to university and into politics and into employment. And if we don't tackle the spread of that idea through schools, then anything that we do today in the other parts of society is going to be undone just by the demographic shift of more and more people being brought up with this ideology. So that's why we decided we were going to focus a lot more on schools, and we've really done it in England with the Department for Education, because they had this ongoing, they were developing guidance for schools, which they'd been doing since, I think, 2017. It's been passed around, and I know there's a separate one in Scotland and a separate one in Wales, but we focused on the one in England. And the Department for Education brought out guidance which we thought was pretty good before the election. We gave it 86%. It's a bit overcomplicated, but it's gone a long way from where the guidance was originally, which was if a child says that they are born in the wrong body, or if a boy says he's a girl or a girl says he's a boy, that the school should treat them as the opposite sex, and if the parents don't agree, they should view the parents as unsupportive, and if the child doesn't want to tell the parents, then the school should not tell them. I'm sure you know all of this. I know it's going on in Wales. It's going on all over the country. And the big point that we kept making to the Department for Education is whatever you think about what's best for that child, and the CAS review was very helpful in unpicking the idea that what is best for that child is always to affirm them. But the school's responsibility is for all the children. And there is no way that you can run a school safely and fairly while forgetting what sex any of the children are, and while confusing the adults and the children about what sex any of the children are. You can't explain what the rules are. You can't expect the children to follow the rules, and the rules are there to keep the children safe. So shifting the focus from thinking, these are very particular children that need to be treated in a completely different way, to thinking about the whole school and think about why do we collect data about a child's sex? Why do we record the information of a child's sex? Why do we use that information? Where do we treat boys and girls differently, and where do we treat them the same? And it's only lawful to treat boys and girls differently because there's a good reason. You're not allowed to say boys do woodwork and girls do sewing. But you are allowed to say, boys play rugby with boys and girls play rugby with girls. And there's no reason that a single child should move between those categories, because those rules are there to keep a child safe, to keep all the children safe. And so we think the guidance that came out in England was pretty good. We hope the next government will finalise it. But it was still overcomplicated, and there are going to be court cases. And what we think schools really need is a model policy. So most schools, particularly primary schools, they don't have a huge admin staff. They buy a lot of their policies off the shelf, HR, health and safety, because each school shouldn't have to make these things up. That's either given to them by the local authority, or they buy them in a package from a commercial service, or it's given to them by the government. And that's what we think should happen here, that schools should be given a model policy that says this is why you record sex, and this is why you shouldn't bend the rules for any child, and this is what you should do when you have a child who's troubled about their sex, and you protect their mental health, you look after them within the frameworks you already have about safeguarding, about children with medical issues, about children with behavioural issues, but you never treat a child as being not the sex that they are. And we think if the government was to come out with guidance like that and stand behind it when a case is taken against a school, that would be a powerful thing. And whether that happens in England or Scotland or Wales, if it happened in court, it would then have an impact all over the country.
I mean, we're pretty sure that there'll be a judicial review of whatever is brought, because there are people on the other side who want to take judicial reviews here as well. But it's also the point about clarity. At the moment, there's no clarity. Schools think they're doing the right thing, or they're doing different things or whatever, but as soon as you make it clear, you I mean, anyone who's done any quantum mechanics, you collapse the waveform, like it's either a wave or a particle, it can't be both. Sorry, that was shit. I wanted to say it and I could see myself coming towards it and I tried to stop myself, but I failed. I just mean the ambiguity. Once it's unambiguous, can this boy be allowed into the girls' changing rooms or not? It can't be, it can't be both, it can't be a bit. It can't be allowed to just stick a toe in, only on Tuesdays, whatever. And the same with the words, like where the government's got to, it seems to have got to this strange place where it's worked out you really can't let the boys into the girls' changing rooms or vice versa. You really can't let them play sport, vice versa. But you might have to pretend in your words that the boy is really a girl. Well, how are you to do that? I don't know, Louise, she's a lovely girl like all the other girls, but Louise is the special sort of girl who can't go into the girls' toilets. Why? My words, I can't say why, because the answer is because Louise is a boy. And if you can't say that, you can't get the rules going. So we think if you write it down, you're forced to see that you actually have to talk clearly as well. And then the other thing that we would say about schools is you can't get a gender recognition certificate under 18. So although I know that the gender recognition certificate is a tiny, tiny number of the kids or the adults or any of them who've been treated as if they're members of the opposite sex, you can explain to a head teacher, you're a primary school. There's literally not one child here who is legally ever for any purpose of the opposite sex. They're all really of their sex for all purposes, including all legal purposes. And then you can think of that closed system and you can think about, are you destroying other people's rights? What about freedom of speech? What about the employment issues? And then when you fix that, well, it's all the same issues everywhere else as well. It's not, the GRC is not magic. I know it looks like it is in law at the moment, but the reason that you say the boys can't go into the girls' showers is the same reason you say the men can't go into the women's showers. And the paperwork doesn't change that.
I mean, just on the impact of there not being GRCs for people under 18, for children, is it does make quite a big difference in terms of how simple you can make a message for schools, because essentially what it means is that all children, the protected characteristic of gender reassignment does apply to children, but GRCs don't apply. So the pure form of the Equality Act, as it were, applies. So you can say all male children must be treated as male. They mustn't be treated less favourably than other male children because they have the protected characteristic of gender reassignment. All female children must be treated not less favourably than other female children because they have the protected characteristic. It's just the comparator and how that works again. So it does make it actually potentially quite a lot simpler to bring the message across from a legal perspective anyway.
So in the remaining minutes that we have before we are controlled by them,
the power.
Whoever forms the next government, what's the future looking like? I don't know if anyone wants to jump in. Yeah.
So the reason we decided on this as our election campaign is not because we think this is going to shift a lot of votes. People are voting on all kinds of issues. We know that most people support protecting single-sex services, but they also vote for all kinds of other reasons. But whichever party makes the next government, they're going to have to deal with this issue, and they're going to have to solve it, and they're going to have to solve it. Oh, sorry.
Did it shift?
Oh. Hello, sorry. So
it's not me, no.
all the libelous things I said without my mic on, I take them back. What did I say? So the reason why we picked this as our campaign was not because we think it's going to shift the election, because people vote on all kinds of things, but because this is going to be an issue that the next government has to solve, and they have to solve it seriously, and they have to understand that it's an issue of women's rights. And so, that's really the message to the next government. And if Keir Starmer doesn't take this seriously, every interview, every phone-in he does, someone's going to be ringing up and saying, do you know what a woman is? Should a man be allowed in a women's changing room? Until they solve it.
You may have seen people say that trans issues are not of interest. So there was a poll that came out last weekend that it was an interesting poll from More in Common, and it asked people, do you think that politicians are talking about this too much, about the right amount, and too little? And the only topic that people said politicians were talking about much too much was something like trans rights or the trans debate or something like that. And they're quite right. It's the most tedious load of twaddle. And that was,
there you go.
That was the actual word I was given to try and say during this session, not penis. That was Akua. So it's tedious twaddle. Of course, when people see this thing about this tiny number of people who are somehow confused about what sex they are, they think, why the hell are politicians talking about this? There's war in Ukraine, there's war in the Middle East, I'm worried about my job, the cost of living, state of the NHS, blah, 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 all the things, and there's people going on about this nonsense. Mm-hmm. But then you say to them, do you think that men should be allowed into women's spaces? And they're like, hell no. I do care about that. I care about it for my daughter, I care about it for me. And unfortunately, the pollsters have taken this, and the politicians have too, that this is an issue of trans rights. Whenever we say women's rights, they say trans rights. So we have to keep saying it's women's rights because people do care about women's rights. And we did our own polling, which came out today. It was in 4 of the papers. People care about it quite a lot, and they expect politicians to fix it. They don't want to have to do it themselves, person by person, in their school. They do not want to challenge some terrifying man late at night in a pub when he's come into the women's toilets. They want that to be sorted out at a national level, what the rules are, what is acceptable to do, and what it's not acceptable to do. They want people to say no again. Mm-hmm. And when a man says, I want to come into the ladies, say, no. That's what we should have said all along. That's what it should always have been, no. Mm. We have to start saying no again, but we can't do it one at a time because we'll get punched. Mm.
I'll just say a couple of words. I think, whoever is next in government, I agree, will have to deal with this. And I think that realisation is dawning on all the politicians. Some are more further ahead than others, but, we've seen an enormous amount of change. It's easy to forget where things were even 3 or 4 years ago. The change in the landscape on this particular issue has been really very significant.
And that's because we've done it. Not one thing would have happened without the people who are here and the equivalent women all over this country doing the same. And we know that because it isn't moving in Canada and it isn't moving in other countries in Europe. Mm. So we're doing it. Well done, Turf Island. Yeah. Yeah.
And we can see, that there are, some of the smaller parties may be not changing their positions, but, the 2 main parties are both in completely different places than they were 5 years ago. And I think it seems to me that both realise that something has to be done. Where they decide to land on it is, anybody's guess, really. Well, I think we can. We know where the Conservatives were going with it, where Labour are going with it. We'll see if they win the election, which they certainly look as if they're going to do. But they have moved. Yeah. They have moved. Yeah.
Well, I don't know that David Lammy would say you could get a cervix transplant anymore.
No. Well, let's hope.
No, develop a service.
Grow.
Sorry.
I understand that there are hormonal treatments that can lead you to develop a cervix.
Quite. Well, speaking as one
That's a man with 3
to
kids.
Another. That's the end of the us.
Sorry, can I just say, I often picture David Lammy when his wife was dilated 10 centimetres. What did he think they were saying to her? What was dilated 10 centimetres? Could he have one of them?
We're trying to build our community back again here in South Wales, and it's been a long, hard journey, as many of you in the room know. We were very pleased with what Philia helped us to do in that leaflet, and we're very disappointed in what's happened in Scotland. Is there any bit of legislation about protecting our community beyond the idea of association that we might be able to be looking to for any kind of support? And I would say that that's also true for women of faith, who also want, on the basis of belief or identity, or by virtue of that kind of characteristic, to be able to associate with clear boundaries of no in place. and I'm looking for what we might use with the future government.
Crikey. Well, I don't know all the legislation, but, you know, obviously the first thing that comes to mind is the Human Rights Act. And, you know, if anything is going to be effective to reinterpret, shall we say, the Equality Act, the only thing really is the Human Rights Act and the European Convention on Human Rights, which comes under it, and which contains an explicit right to freedom of association that Maya's already spoken about. But, you know, that's a big challenge. It's a big case to take, to challenge the way in which the Equality Act is interpreted currently by reference to the Equality Act in relation to lesbian-only or gay men-only associations. And in any event, you need to wait to see what happens in For Women Scotland.
The public sector equality duty is this requirement on all public bodies to proactively make sure that it doesn't do anything unlawful. So not just avoid doing unlawful things, but avoid...
To have due regard
to have due regard to, yeah, okay, but, you know, something more than just don't turn up in court, but proactively have due regard to what you're doing, and to go on, you tell me what it says.
Okay, yes, you have to have due regard to the need to eliminate discrimination, etc. But you've got a problem with the public sector equality duty. If the only definition of sex in the Equality Act is legal sex, there's no underlying concept of biological sex to fall back on. So, I mean, and this applies even to applying the exceptions in the single-sex services provisions. You know, if a service provider is looking at setting up a single-sex service, then you've got to think, what does sex mean in that phrase? In that phrase, single-sex service, does that mean single legal sex service? And if it does, then applying the exceptions becomes a nonsense, because the exceptions purport to allow...
I was going to make a happier point.
Yeah, sorry, I'll come back to that. The exceptions seem to allow you to exclude trans people from the single-sex service if it's, you know, proportionate or whatever it is to do. But there's no underlying definition of biological sex which allows you to do that. So it's very, very difficult. And I'm not sure that the public sector equality duty is going to help you with that if things remain as they are in the state of confusion they're in.
I agree, but if things are improved, you know, if For Women Scotland win, and if the protected characteristic of sex is clarified as meaning sex, then the public sector equality duty can be used in the way that it was originally intended to be used, which was to say that when a public body is setting a policy, they have to think, how does this policy affect women? How does it affect men? How does it affect gay people? How does it affect disabled people? And for some policies, it'll be, well, it doesn't. You know, the policy's the same. But that's what the public sector equality duty was for. And it's a more proactive thing than just allowing. So, you know, if we can get to the point where they're clarified, then potentially the public sector equality duty becomes something you can use. But if it's not, then it becomes, as Helen said, something that's used against us.
I mean, I think we may end up having to go the whole way on this. You know, if they don't hear our argument, if they want those pieces of paper to say that men can be lesbians, that men can be women for the purposes of doing intimate exams on women, etc., then they cannot have their piece of paper. So if they want their piece of paper, they have to understand that it can't destroy our rights. And we can't let them keep having both of those things running at the same time. The piece of paper doesn't destroy your rights, but it does destroy your rights, whichever way we're arguing from.
But also, just in terms of what Maya said about the public sector equality duty, I think a lot of the problems that are facing, you know, the sort of decimation of lesbian life don't emanate from the public sector anyway.
No.
As a lot of it is just, you know, basically, you know, private associations or private clubs and bars or whatever who just have gone fully inclusive. Yeah.
But also the indoctrination of kids. I mean, young women being told that their sexuality is exclusive and bigoted.
Yeah. I do think that one way in, you know, politically rather than legally, is for people who are in favour of inclusion of trans people in these categories, to understand that the law doesn't go as far as self-ID, that it only goes as far as GRCs, because literally nobody agrees that a lesbian is somebody who fancies women and biological males with a piece of paper. Nobody agrees with that. And I remember seeing that being put to Katie Montgomery on Twitter. And Katie Montgomery was like, well, don't be ridiculous, that's ridiculous. Nobody just fancies people with a GRC. And I think, you know, there's a point of agreement there. If we can, if we can look at where can we agree and move forward from there, which is something I think is fruitful, because at the moment, you know, there's almost no common ground, but that is a piece of common ground.
The question was, what is it going to take to get BBC Women's Hour to invite you, Helen?
Jo was great on Woman's Hour. She was brilliant. That was an amazing programme. That was Woman's Hour doing what it's meant to do. Listen, if they won't talk to me, I'll talk somewhere else. I've become very, very radical on all of these things. Woman's Hour can die if it wants to. If it wants to do, you know, like they invited Emma Hilton on once, and then they didn't call her back to tell her they didn't want her, and they did a thing on, do you share your bathwater to save money? Instead. If they want to do that, off they can go, and we will be over here talking to new media, podcasts, setting up our own things, talking on Twitter among ourselves. I don't care.
So the question is about the Equality Act and single-sex spaces, and if I've summarised correctly, is there a way to tighten the Equality Act so that if there is a need for a single-sex space, that an organisation or institution must provide it?
Yeah, I think the question, it's about, I mean, the Equality Act on the face of it is permissive in relation to single-sex spaces rather than making them mandatory. So service providers and others can provide single-sex spaces if they want to and if they satisfy the criteria. And that does seem somewhat problematic in some respects. There is a way to challenge a failure of a service provider to provide single-sex services in some situations, which is by arguing on the basis of indirect discrimination, because it can be indirectly discriminatory, for instance, against women not to provide single-sex changing rooms for women in the leisure centre, because it puts women at a particular disadvantage by comparison to men if they have to change in the presence of the opposite sex. So there's that, but you know, as I said earlier, indirect discrimination is a very tricky cause of action. It's very hard to win those cases. It's always possible for the respondent, you know, the service provider or the employer or whoever it is, to argue that the way that they've approached the matter is proportionate, a proportionate means of achieving a legitimate aim, so justified. That's a defence that's available to indirect discrimination that's not available to direct discrimination. And incidentally, that's the basis on which the trans rights lawyers argue their position, that they've got indirect discrimination rights as well. So yeah, I mean, I think there might well be space for having some mandatory requirements. There are, of course, in workplaces to a certain extent with toilets and schools, but no, they don't come from the Equality Act.
And there certainly are international treaties as well, particularly around prisons.
But also, I think one of the things we have to get beyond is the idea that an organisation can provide, you know, a toilet with a picture of a lady on the door and say, oh, it's not a single-sex service. That is a single-sex service. If you've told the women coming and told, including by means of that pictogram, which everyone understands, that this is female only, then you are providing a single-sex service. And we, you know, there have been cases, nothing to do with trans, but to do with just bad management of facilities, where employers have forced women to share facilities with men, and that has been discrimination. So I think we need to get to a point where people are clear that you can have a mixed facility, you know, a mixed service. This is a mixed service. There are men and women here. Or you can have a facility that is single sex, but what you can't do is pretend that you're not, you know, or we're not using the exceptions because this isn't a single sex service. Though, as long as you've told people that this is women only, it has to be women only.
Yeah, it can't be self-ID either.
No.
That would be unlawful discrimination against men, essentially.
So clarity is the answer to it. You know, we're just going to have to force in every place the fudges.
Yeah, and so quite a few of the politicians have been talking about you ask them about single-sex services and they answer about safe spaces. Have you heard this? Mm-hmm. You know, they're trying to get away from that. They're trying to get away from the clarity of saying this is single-sex to saying it's a safe space. And then they're saying, and of course trans women need to be safe too. Well, yes, trans women need to be safe too, but not in a women's space. So just getting them back to this is about single and separate sex services, and if you've put that sign on the door, you are using the exceptions in the Equality Act. You know, some people think you have to like do something to use the exception.
Application,
Yeah, there is no application. You're using it because you put that sign on the door. You can't put a sign on the door of your pub and say only men in the bar. That would be unlawful discrimination, but you can put the sign on the door that says only men in this room because the urinals are in here, and that's a single-sex service.
Yeah, I've nothing to add. Please, I want plaudits for that.
The question was, after telling a story about a Labour candidate who's been parachuted in, who said that the Labour Party don't plan to touch the Equality Act, but they plan to make things clear and single-sex will apply the single-sex provisions correctly.
Well, I mean, this is ridiculous. It's not the government that applies the provisions. It's the service providers. So it's not, you know, I mean, I think what the Labour Party have said is that they'll put out guidance on how to apply the single-sex service provisions correctly. The Equality and Human Rights Commission did that 2 years ago, and you know, we still see a lot of services which are provided on a self-ID basis or otherwise incorrectly, and a huge amount of misunderstanding about how they should be applied. The problem is fundamental to the way in which the GRA and the Equality Act interact. You know, I've absolutely no doubt of that, and it's not only that the problem is fundamental and insoluble through litigation, but also that the legal landscape here is so complicated that really only specialist lawyers can understand it, which is why a lot of these cases, almost all of them, the claimants are represented by King's Counsel. You know, these are not cases which any, you know, young up-and-coming barrister can pick up. They're really, really complicated, incredibly expensive, and the burden should not be on individual members of the public to try to chart their way through, you know, whether people who are gender critical or people who are trans activists. Nobody should be in the position of facing this extraordinary labyrinth of legal provision, which almost nobody can understand.
And by the way, the Employment Tribunal is meant to be a low-cost venue where you can turn up and represent yourself. It's meant to be friendly. It's meant to be when your boss is an absolute jerk and you have to go along and say, you know, oh, he was, you know, doing this, that, and the other, and the judge listens to you and doesn't worry about the fact that you're not using all the proper legal language and so on. It's not meant to be where King's Counsel is doing stuff.
The vast majority of cases in the Employment Tribunal, at least one party is unrepresented. Yeah. I mean, the vast majority. These cases are truly exceptional. I mean, to have King's Counsel appear in the Employment Tribunal on a trial is, you know, it's not.
And to have them on both sides. I mean,
and both sides is exceedingly rare, I will say.
But I think also it's not just it's not just about it being legally complex. It's about the social acceptability of being able to say no to these men. There are situations where it is very clear there is no legal complication, and you can read the EHRC's guidance, and it tells you you can have a policy and you can implement that policy, but that does mean somebody has to say no. And people don't want to say no. And, you know, I think there does need to be a cultural shift where we can say, no, sorry, you know, I'm not disrespecting your identity, but the rule here is this is female only because this space is for the dignity and privacy of women.
I mean, the big thing that has changed in the few years that, you know, I've been talking about this in public has been that the other side has to speak. So in 2018, 2019, 2020, they didn't. And often they could stop me from speaking at something because there wasn't somebody else and the person didn't want to run the event unless there were both sides. Now they have to speak. So after Kemi Badenoch said that the Tories would make the Equality Act clear if they were re-elected, I think I was on 4 or something, or between us we were on 4 or 5 things that day. And they often had a trans woman, and that trans woman would say, I'm female, you know, some of them said, I've had the surgery, or I've been through the procedure, or I've got all my paperwork, and now I'm female. And I mean, we've just got to get them to say it and say, no, you're not. I mean, Nick Ferrari actually ended the call when I said, I'm sorry, I don't think that castrating a man turns him into a woman. And the theory is that from now on, I must not say the word castrate, at least on the on LBC or the BBC or whatever. But I mean, you know, the castrated man had to sit there and have me say this to him. And we're going to have to say this to an awful lot of men, and I'm sorry, I don't want to upset people, but you know, I often quote the sign from my youth that they would have up in shops behind the till saying, do not ask for credit because a refusal often offends. So don't even try to come in, and then I won't have to say you're not a woman.
So we have time for one more question in light of particular international treaties and organizations, CEDAW being one. What happens if we have an international set of laws, policies, procedures that no longer define women as those people with vaginas? That was my word. I didn't mean it in a bad way.
It's very depressing. I mean, we are a sort of a holdout. We are like the sandcastle as the tide is coming in, you know, and the question is, does it turn, or does the tide turn before we've washed everything away? Because I do think the tide will turn. I mean, I don't think anything this mad really lasts forever. But also, it's so fashionable at the moment. And anything this fashionable goes out of fashion. Like, I just don't think that the same people who are calling themselves non-binary, they, them, will still be doing so in 10 years and possibly not even in 5. Like, I'm already hearing kids say things like, you know, some kid who's being really tedious, somebody will say, oh, so they, them. You know? So if we're there, but the question is, does everything get destroyed first, or are we able to hang on to some of it so that when the tide recedes, we don't have to try to build it all again? And there I'm really not very sure. I think we may be able to hold on to some of it here in Turf Island, but then the good thing is, and to be very serious for a moment, which I am not always, like I joke about being called a bigot and a genocidal maniac and all of that, because what else am I to do? Like if people are going to call me these things, I've got to joke about it. I'm really not those things. I actually do care about everybody's human rights. I mean, I do really, really care that people who want to see themselves in a particular way are free to do that as long as it doesn't impact on other people. And if we can think about that as the vision, we can show people how to do it. You don't have to make, you know, some teenager who calls herself they, them feel bad about herself or whatever. You know, you also don't get her to cut her breasts off, and you don't get her to go into the men's toilets. But you know, if we can think about everybody's human rights, what it is we're trying to achieve here, the fact that we're mammals, we come in 2 sexes, we have a variety of odd beliefs, all of us, and then we can show people and we can hopefully rebuild and build back out. I think America might collapse really quite quickly on this. Very volatile country. So, you know, I just think we have to hold on and wait for the tide to recede if we can.
And I think on CEDAW and the Istanbul Convention, which is on violence against women and girls specifically, you know, these countries who agreed this, it's like the Sex Discrimination Act 1975, they thought this was about men and women, and they still think it's about men and women. You will not get an agreement to, you know, include erotic cross-dressers as women through the UN. You know, you might get it in the headquarters of the UN, in the you know, the Secretariat, but not through the countries. And the same in Europe in the Istanbul Convention. But in these international treaties and international bodies, they use gender so much. And then they use this kind of bait and switch between sex and gender. So I've seen with CEDAW, you know, the CEDAW Convention is all about men and women, but then there's, you know, they have these other sort of supplementary things, and somewhere in like supplementary 39 paragraph blah blah, somebody got in LGBTQ or LGBT or something, and then they say, see, that means women in the whole of CEDAW means self-identified women. I don't think it does. That's not how international treaties are made. But the secretariats of these international bodies are populated by the woke, and they're playing fast and loose.
Jo, I can give it, it's not an international law, but it's an international example that I know Carleen will know a lot about. So the La Leche League is a charity that was, it's, you know, by women, for women, mothers to mothers, support for breastfeeding, and there's an international body, And then there are local chapters of it, and I'm sure in many countries there are charities, and our one here in GB is a charity. So LLLI has gone full self-ID, and it talks about chest feeding, human milk feeding, supporting male lactation, etc., etc. And they're bullying, in particular, the British branch of LLL, and their power, because LLLGB is actually a UK charity constituted under UK law, so it doesn't have power over that, but it has power over the board because a majority of the people on the board have to be LLI certified, and it can take away their certification. Now, is it doing that in South Africa? Is it doing that in countries of the global south? Absolutely not. It's allowing them to say, in our local environment, woman means woman, we couldn't do this sort of crap here, is the short version, They're trying to bully the countries they think that they can do it in, and bully the countries that don't make them look bad in a sort of, post-colonial, we're imposing the global north on the global south way. And I think a lot of the international law will be like that too. They won't really fancy telling, Ghana or Brazil or somewhere. Brazil is a bit of a mess, but separately from that, how they must do things. They'll just bully Canada and Australia and Ireland and the UK. So that might hold back the tide on the international level a bit.
Yep.
I mean, I'm not an activist, so I'm not, really in the business of saying whether or not I think legislation should be repealed. I find the way that the GRA interacts with the Equality Act really complicates matters. But beyond that, I take Helen's point that repealing it would not make an enormous amount of difference. And more importantly, I take Helen's point that we can't, without going against a decision of the European Court of Human Rights. I mean, if there's a way in which, that can be done effectively and without putting us into very, very deep water with the European Court, then I'd be very happy to know about it. But I just can't see how it could be done, and I can't see what particular difference it would make other than slightly simplifying things in a way, in relation to the Equality Act, in a way which could be done just by the government putting together some regulations saying Section 9 of the GRA doesn't apply to the Equality Act.
I mean, to be very clear, I hate this bloody law. It's just, every day we get up and we do something. Everybody here does that. Every day we get up and do something. I don't know what I would get up and do that is any different from what I'm doing now if the end goal was to repeal the GRA. I would still be doing the same things that I'm doing now, because it's taken us a long time to get to here, and the way to get to there, to get back to where we want to unroll and unpick everything. And it's not just the law. I mean, it is there. I see your point that it's a stone in your shoe or something like that you need to take out, but it doesn't fix anything else.
And the way that you would repeal the GRA in a way that is safe is by doing it, is by being able to say that the trans people's human rights, we recognise what they are, and they're protected by the Data Protection Act. There's a degree of privacy that a trans person can have over their sex. It's a very limited degree of privacy. It's like the degree of privacy you can have over the fact that you're pregnant. Like when you first find out you're pregnant, your doctor doesn't have the right to tell anyone, your employer doesn't have the right to tell anyone, but at some point, if you walk out of the house, everyone's going to know. Being trans is a bit like that, in information terms. So, if we could focus on what are the trans rights and how are they protected in everyday life, and then what are the rights on the other side, the Article 3 rights, there's freedom of association, how are they protected? And then you either get to the point where you're protecting both of those rights and the GRA sort of becomes a historic thing. And the weird thing that the GRA does, if you are religious, if you're Christian and you don't believe in the same-sex marriage, but you think you're the opposite sex and you want to get married in the Church of England, because the Church of England recognises gender recognition certificates, they will marry two people of the same sex if one of them has my head is exploding. My head is exploding. you can't take someone's marriage away. And I don't know how you negotiate with the Church of England. So, you know, and like that's not the first thing that I would do. The first thing I would do is get the government, get public bodies, get private employers and service providers to recognise the rights on this side, the Article 3 rights, the freedom of association, the privacy and dignity of women. And then it may get to the point either where GRCs become irrelevant, or they're such a block that then you have that challenge. But I don't think you start there.
And we have to make the case. Here. We have to make the case that either they're very minor things, or they're, you know, they're actually a big thing that gives you a lot of rights. And if it's a lot of rights, well, then they can't have them. If it's minimal rights, I don't care, you know, but we have to work our way back there, telling them what is on the other side, because they said it in the European Court of Human Rights judgment. It said it doesn't matter to society. You know, these poor suffering individuals, and they didn't say the word women, but you know, the fact is they said women can just budge up. And we have to explain women cannot budge up. That's how you would get rid of the Gender Recognition Act anyway, is explaining that women cannot budge up, and the request to make us budge up destroyed our fundamental rights to such an extent that you have to get rid of the Gender Recognition Act. You can't just say repeal the Gender Recognition Act, because they won't do it. Nobody repeals laws. Can you imagine a government giving that much time and effort to that without you having made the case as to why?
Yeah, and also, you know, we hear very often that all the GRA does is to allow trans people to sort of be married and buried in dignity with their paperwork in order. And you know, if the effect of the GRA on the Equality Act were clarified in the sense that's been suggested, then that is essentially what it would do.
And they're welcome to it. They're welcome to their bit of paper saying what it says on their gravestone. Of course, I don't care.
But the other thing is, I would like a piece of paper that shows that I'm female. I mean, I think Christine Goodwin went to the European Court of Human Rights saying that he wanted a birth certificate that showed that he was female. Well, I would like a birth certificate that shows that I'm female. I currently don't have one because my birth certificate looks just like a trans woman's birth certificate. You know, I think focusing on our rights, and can we have a certificate? Can we have a system of identification that allows people to say, I'm female and I can prove it, whether it's for sport, whether it's for employment, you know, whether it's just for your identity, which is what Christine Goodwin wanted.
Separate gender and sex.
I don't care the gender. I'm not going to put the star sign on or anything either, you know. I just, like, why would we even certify this thing, you know?
The gender recognition certificate was a very analogue solution to the problem. It was an analogue solution where if you wanted to show that you were the person who owns your identity, that I am me, the person who my mother gave birth to, I show my birth certificate. But if I'm doing that to get insurance, I don't actually need them to know my sex. And now, you know, all that information is digital. All of those attributes are separate. When you're dealing with information digitally, all you do is you say, I consent to share the information that is needed for this particular purpose. And a trans person, when they share their information, their medical information between doctors within the hospital, that needs to be accurate. Whatever their pronouns are, their doctors, and not just their doctors facing them who can see who they are, but the computers that are doing the looking at the data, you know, the monitoring. All of that needs to be based on clarity about their sex. In another situation, you know, going to the bank or, you know, try and show that they're over 18 in the supermarket because they want to buy alcohol, they shouldn't necessarily have to show something that shows whether they're male or female, because it doesn't matter. The same way you don't have to show your address. You can all those pieces of information can be accurate, and they can all be separate.
I think
No, it doesn't.
No,
it doesn't.
But it gets
an
you
answer to the gender recognition system.
And it gets you to a point where you can say, well, that right is protected in a different way. Sorry.
We've got to stop.
Sorry.
yeah.
We have to stop.
So before I dismiss all of you, because there are drinks in the bar. The bar is open. It's open for an hour. We would like you to leave the auditorium in an orderly fashion. But before you do that, can you please put your hands together for three phenomenal women?
Thank you.